Department of Attorney General executed a comprehensive review, and that included the review of dozens of citizen letters and emails, which is the most actually my administration has ever received in connection with a single public body. We reviewed each board meeting since January, which of course have been very well attended by the public. Of the over 70 public comments at the January 24th, 2023 meeting, a substantial portion were directed at the board's lack of transparency, and they questioned the board's compliance with county rules and policies. And here's what we found. The actions of some of the members of the Ottawa County Board of Commission clearly demonstrate a violation of the spirit of the Open Meetings Act and a blatant violation of public trust and the tenets of government transparency. Now, it's apparent that certain incoming members of the board met prior to the January 3rd, 2023 meeting to discuss the motto change, termination of the public health director, corporation counsel, elimination of the DEI program, and hiring of a new legal counsel. And this was all done outside of the public view and to execute their will without any public interference. However, there appears to be no actionable violation of the Open Meetings Act or of other relevant laws at this time, which is why what I'm doing is this. I am proposing amendments that would strengthen the Open Meetings Act. The OMA is intended to protect the right of all Michigan residents to know what goes on in government by shedding light on the official acts of public bodies and enhancing responsible decision-making, and thus promoting government accountability. But it's not without fault. So these changes would firstly require a public body to include a meeting agenda along with a notice for the public meeting at least 48 hours in advance of the holding of the meeting. And it would limit the ability to modify that agenda during a meeting, except in exigent circumstances. And secondly, it would amend the definition of the term public official to include a person who has been elected or appointed to public office, even if they have not yet actually taken their oath of office. Current OMA does not require an agenda. It does not define public official to include successful candidates following the election up until they take the official oath of office. So I guess the question really is, where do we go from here? Well, residents may have rights and remedies under the OMA and in the Michigan Constitution, such as a citizen has the right to commence a lawsuit against a public body under OMA to challenge the validity of a decision of that public body made in violation of the act. And I know we've seen at least one of those lawsuits. A citizen may also obtain a court order compelling a public body's compliance with the act or enjoining further non-compliance.
Lansing, Trevor Gonzalez, 13 on your side.
Trevor, thank you.
A citizen who succeeds in a lawsuit filed under the Open Meetings Act may actually recover court costs and actual attorney fees. Citizens may contact the audit section of the Community Engagement and Finance Division of the Michigan Department of Treasury for concerns they have about the expenditure of municipal funds. And the Treasury Department can be contacted at 517-335-7469, or you could send a letter to 430 West Allegan Street, Lansing, Michigan, 48922. And the state treasurer can also refer the results of any audits to the Department of Attorney General for review as to possible criminal prosecution or the filing of a civil lawsuit. The Michigan Election Code provides for the recall of elected officials, including county commissioners, for their conduct during their current term of office through a recall petition process. And for elected officials with 2-year terms, a recall petition can begin after an officer has held their position for 6 months, but cannot be filed in the final 6 months of the official's term. And for more information on that, you can go to MCL 168.951. There are criminal penalties for OMA violations, as many people might know. A public official who intentionally violates the OMA may be found guilty of a misdemeanor and may be personally liable for actual and exemplary damages of not more than $500 for a single meeting. And there's also a criminal remedy. A public official who intentionally violates this act is guilty of a misdemeanor, and that's punishable by a fine of not more than $1,000. A public official who's convicted of intentionally violating provision of this act for a second time within the same term can be guilty of a misdemeanor and be fined up to $2,000 in the same 1-year potential sentence. Now, why does this matter, right? Why is all of this important? Well, full participation in the democratic process is good governance, right? And elected officials across the state, we may come from different regions and different backgrounds and different political beliefs, but we really should seek to serve the greater good of the residents of this state, no matter who we are. And we should seek to actively engage the public in the work of the government to build public trust through accountability and to improve our effectiveness through public participation in our decision-making. This is consistent with the underpinnings of the Michigan Constitution, which many of you know actually says all political power is inherent in the people, and government is instituted for their equal benefit, security, and protection. So the notion of government transparency is just part of our national story. And so it's important that the power that government officials have not be abused. And we can also look, of course, at the co-equal transparency statute, which is FOIA, right? The Freedom of Information Act. And at its reflective core, its purpose is to provide citizens with full and complete information regarding the affairs of government and the official acts of those who represent the people as public officials and public employees. So they may fully participate in the democratic process. So, another thing that we're going to be doing is making recommendations to the legislature about changes in FOIA that we think are important. As many of you know, some of the individuals who are in the legislature right now, and I'd say notably Senator Moss and Senator McBroom, have been really vocal about indicating that they want to make changes to FOIA as well. So, one of the things that we are, officially, I guess, recommending to the Ottawa commissioners is, not only does my office have resources on FOIA and OMA on our website for any local elected officials to help them better understand the laws, but the Michigan Association of Counties also has resources for new and for inexperienced county commissioners to ensure that they're the best public servants that they can be. So, those are essentially the findings that we have made in regard to this investigation. It's the first such investigation that we've done since I've been in office, and in talking to some of my staffers who are on, and they're going to be available to answer some of your questions if there are things I can't answer. But I have Tom Quasarano on, who handles our FOIA and OMA related matters, and also the head of my state operations division, Jessica McGivney. But the thing that's interesting about Tom is that he's been in the office so long that he was there when these laws first took effect. And you'll have to correct me on this if I'm wrong, Tom, but I think this is the first time that the office has really undertaken this kind of an investigation into potential OMA violations. And so really what we learned is that OMA needs to be strengthened. There's no question about it. It needs more teeth and it needs more specificity so that the law can be properly enforced, and so that the people of the state know that their government officials are acting with appropriate transparency.